On April 12, 2016, at 8:43 a.m., you sign the release order. The defendant's name is printed in clean black ink beneath the seal of your court. The charges include possession with intent, illegal firearms, conspiracy. The evidence file is thick. The arrest report is thorough. The prosecutor expects a remand to custody. Instead, you cite procedural error, a technical flaw in the chain of evidence, a misfiled warrant timestamp. You write the reasoning in controlled language. You reference precedent. You maintain eye contact with no one. By 9:02 a.m., the man is walking out of the courthouse. By 9:14 a.m., your phone vibrates once. No message, just a signal. Confirmation that the agreement holds. You are a federal judge. You took an oath to uphold statutory law, constitutional protections, and impartial review. Today, yet you demonstrate that those words can be interpreted. You tell yourself this is a single deviation, a correction of imbalance, a favor in exchange for stability. What you understand, though you do not say it aloud, is that this signature cannot be undone. Court transcripts persist. Surveillance cameras record. Patterns accumulate. From this moment forward, your rulings will no longer be evaluated only by appellate courts. They will be evaluated by men who do not file appeals. Level 1. The Quiet Compromise. Before April 12th, there were smaller moments. It began 18 months earlier with a dinner invitation you almost declined. A local business association fundraiser. Judges attend these events routinely. You shake hands, you exchange cards, you reinforce civic presence. That night, a man introduced himself as a logistics investor. Polite, measured. He spoke about infrastructure delays, about bureaucratic inefficiencies harming economic growth. He never mentioned the cartel. He did not need to. You already knew which companies moved goods along certain highways at certain hours. Weeks later, a case landed on your docket involving one of those companies. Regulatory violations. Customs irregularities. Nothing overtly violent. Nothing dramatic. The defense attorney requested a private chambers meeting. Inside your office, the proposal was framed as professional courtesy. Expedite a ruling, interpret an ambiguous statute favorably, reduce financial penalties. In return, campaign donations would flow toward judicial retention committees that quietly supported your seat. Nothing illegal on paper, nothing provable. You told yourself the system was already compromised. Prosecutors negotiated, politicians lobbied, corporations influenced outcomes. You would simply balance influence. The first adjustment you made was minor, a narrowed interpretation of liability, a reduced fine. The ruling attracted little attention. A week later, an envelope arrived at your home. Not cash, not threats, just a handwritten note thanking you for your fairness, accompanied by an invitation to a private security consultation, free of charge. You declined the consultation. But you did not report the note. That omission was the first compromise. Not the ruling, the silence. You began to understand that corruption does not announce itself as betrayal. It presents itself as alignment, as mutual benefit, as professional pragmatism. You lost nothing visible in that stage. Your robe remained pressed. Your courtroom remained orderly. What you lost was internal friction. Level 2 procedural immunity. The system becomes visible to you in fragments. At first, it is scheduling patterns. Certain defense attorneys request continuances at precise intervals. Prosecutors assigned to specific cases appear underprepared, almost intentionally restrained. Evidence arrives incomplete. Witnesses become unavailable. You begin to notice that your courtroom is not isolated. It is a node. One afternoon, a sealed indictment involving a mid-level cartel distributor lands on your docket. The charges are substantial: trafficking, money transfers, weapons enhancements. The prosecutor argues for pretrial detention, citing flight risk and witness intimidation. The defense argues procedural violation. An affidavit was signed 6 minutes before the warrant was time-stamped. A technical irregularity. In earlier years, you would have weighed the totality of circumstances. Now, you focus narrowly. You restrict your analysis to the defect. You dismiss the detention request. The distributor walks free pending trial. 2 days later, a witness retracts testimony. 2 weeks later, the case weakens. You feel the shift. Not guilt, not pride. Something more clinical. Efficiency. You are no longer reacting to influence, you are anticipating it. The stress increases, but it is contained. You check your mirrors more often while driving home. You vary your routes. You instruct your clerk to route certain filings directly to your private review. The moral friction that once required justification now requires only routine. Yet you tell yourself that procedural integrity is paramount, that rights must be protected even when defendants are unsympathetic. And technically, you are correct. What changes is not the law. It is your application. Each time you narrow a ruling to its most technical reading, you remove another layer of discretion. You reduce complexity. You simplify decisions. You are building a pattern of judicial predictability. Outside the courthouse, predictability is currency. You are no longer being asked to help. You are being relied upon. Level 3. The signed order. The responsibility shifts the morning you receive the case involving a homicide. The defendant is not a distributor. He is identified in federal briefings as an enforcer. Multiple counts, murder in furtherance of organized crime, witness elimination, obstruction. The evidence includes ballistics reports, phone intercepts, financial transfers. The prosecutor requests immediate detention without bail. You review the file alone in chambers. The evidence is stronger than anything you have previously adjusted. There is no convenient clerical error, no flawed timestamp. At 7:18 p.m., your personal phone vibrates. A single message from an unlisted number. Procedural review, as before. You do not respond. That night, you reread the affidavit. You identify an arguable weakness in the way surveillance authorization was renewed. It is not decisive. It is interpretive. In open court the next morning, you suppress a portion of the intercepted communications on constitutional grounds. Without those recordings, the prosecution's argument for pretrial detention weakens. You grant conditional release. The courtroom remains quiet. Reporters scribble. The prosecutor's jaw tightens, but remains professional. You cite precedent. You reference due process. 3 weeks later, a key witness is found dead in a parking structure. The news cycle does not connect the death to your ruling. There is no proof of causation. The enforcer has not been convicted. Legally, you are insulated, but you understand sequence. For the first time, consequence is not abstract. It is measurable. A name removed from a docket. A testimony erased. You sleep less. You tell yourself that judges do not control what defendants do outside court. You interpret law. You do not enforce it. Yet you know the release order was not neutral. It was aligned. The shift becomes procedural inside you. You stop debating internally. You stop weighing ethics against pressure. You assess only exposure risk. You are no longer compromising for favor. You are managing outcomes. Something irreversible has happened, not in the courtroom, but in you. Level 4. The containment illusion. The stakes increase gradually, then all at once. By your 5th adjusted ruling, the pattern is no longer incidental. Certain cases arrive on your docket with quiet regularity. Defense motions are calibrated precisely to arguments you have previously accepted. Prosecutors begin filing objections more aggressively, but they lack proof of misconduct. They suspect bias. They cannot demonstrate coordination. You sense scrutiny tightening. An internal Judicial Review Committee requests clarification on several suppression decisions. Routine, they say. Random sampling. You provide footnoted responses supported by precedent. Your reasoning remains defensible. It always is. Outside the courthouse, security around your home increases, not officially. 2 unfamiliar vehicles idle on your street at inconsistent hours. You are not sure whether they are there to protect you or monitor you. You understand the imbalance now. The cartel does not threaten directly. It does not need to. Its leverage is structural. It has positioned you in a role where compliance ensures stability and deviation invites unpredictability. A high-profile trafficking case reaches your courtroom involving cross-border shipments and multi-million-dollar seizures. Federal agencies coordinate tightly. Media attention intensifies. This time, the expectation is not release. It is delay. You grant continuance after continuance, citing discovery disputes, procedural fairness, translation review. Each delay buys time. Each postponement fragments prosecutorial momentum. Behind the scenes, evidence grows stale. Witnesses relocate. Financial trails cool. The risk to you grows with each public appearance. You notice plainclothes officers at the back of your courtroom. You notice investigative reporters lingering longer than usual. Your freedom narrows in subtle ways. You avoid social events. You limit phone calls. You begin storing sensitive case notes in a locked drawer rather than digital archives. Paranoia does not feel dramatic. It feels practical. You once believed you were containing influence through controlled technical rulings. Now you realize influence is containing you. Level 5 authority under leverage. Your authority expands as your options contract. By now, thus you preside over some of the most sensitive criminal dockets in the district. Senior attorneys address you with careful precision. Younger prosecutors study your prior rulings before stepping into your courtroom. Defense teams treat you not as sympathetic, but as predictable. Predictability becomes your power. When a major asset forfeiture case reaches your bench, millions in seized property tied to shell corporations, you recognize the architecture immediately. The companies are layered across jurisdictions. The paperwork is dense but deliberate. The request is not for dismissal. It is for narrowing. You issue a ruling that limits the scope of forfeiture to a fraction of the assets, citing insufficient tracing between accounts. Technically correct, practically decisive. Within weeks, funds flow again. Your chambers feel different now, larger, quieter. Clerks rotate frequently, either transferred or reassigned. You suspect some leave voluntarily. They sense something imprecise in the atmosphere. Threats begin arriving indirectly, not toward you, toward others. A former prosecutor involved in one of your suppressed cases resigns abruptly after a home invasion. No charges filed, no suspects named. The message is not spoken. It does not need to be. Your control appears to expand. You determine detention. You determine admissibility. You determine timing. But each determination is shaped by the knowledge that deviation carries asymmetric risk. Simplicity disappears. Every ruling now carries dual analysis: legal defensibility and external reaction. You maintain composure in court. You speak evenly. You cite statute with calm precision. Inside, you track variables constantly. Well, who is watching? Who is aligning? Who might defect? You once believed you were influencing a criminal system from within an institutional one. Now you understand you are dependent on both. The bench elevates you publicly. Privately, it binds you. Level 6. Cognitive fragmentation. Sleep becomes inconsistent. You wake at 3:12 a.m. without alarm, reviewing motions in your head that were already decided days earlier. You replay transcripts not for legal clarity, but for tone. Whether you revealed hesitation, whether you paused too long before issuing a ruling. Hyper-awareness replaces confidence. You begin separating your identity into compartments. Publicly, you remain measured, disciplined, analytical. Privately, you operate on constant risk assessment. Every knock at the door triggers evaluation. Every unknown number demands calculation. Oh, you reduce social contact. Former colleagues invite you to judicial conferences. You decline. You avoid unscripted interactions. Even casual conversation feels like exposure. The system now occupies cognitive space continuously. You do not think in terms of justice or injustice anymore. You think in terms of stability, continuity, predictability. You notice something else. The cartel no longer needs to contact you directly. No messages, no signals. The alignment has become internalized. You pre-adjust before pressure arrives. That realization unsettles you more than threats ever did. Identity distortion develops gradually. When you first took the oath, you believed authority insulated you from external coercion. Now authority is the channel through which coercion operates. Yet you begin keeping handwritten notes, brief reflections you never intend to share, not confessions, observations. You write about procedural language becoming a shield, about neutrality as camouflage. You destroy the pages after writing them. Sleep erodes further. You drink more coffee. Your hands remain steady in court, but your jaw tightens unconsciously when certain case names are called. You are not visibly unraveling. You are functionally adapting. The erosion is not dramatic. It is cumulative. And you understand something with quiet clarity. The system does not require your loyalty. It requires your continued utility. Final reality. You once believed corruption was an action, a signature, a ruling, a dismissal. Now you understand it is a migration. It moves slowly from external pressure to internal alignment, from requests to anticipation, or from negotiation to reflex. When federal investigators eventually begin reviewing sentencing irregularities across multiple districts, your name surfaces statistically before it surfaces personally. Data analysis reveals patterns. Suppression rates slightly above average in organized crime cases. Pretrial releases marginally higher under specific defense firms. Asset forfeitures narrowed with unusual consistency. Nothing individually illegal. Collectively improbable. An ethics inquiry opens quietly. You are not arrested. Not immediately. The institution proceeds carefully. It protects itself first. You are interviewed. You provide structured explanations. You reference precedent again. You cite judicial discretion. You realize, sitting across from internal counsel, that you sound convincing even to yourself. That is the final distortion. You no longer distinguish between justification and belief. Whether you are removed, forced to resign, or publicly censured becomes secondary. The greater truth is structural. The cartel did not need to own you entirely. It needed to integrate you partially. The system of law remained intact on paper. Courtrooms continued operating. Verdicts continued being delivered. Appeals continued being filed. From the outside, stability persisted. But within that stability, micro-adjustments accumulated. Outcomes shifted. Timelines altered. Enforcement weakened in increments too small to headline, too consistent to ignore. You were never the architect. You were a junction point. If you disappear, through resignation, indictment, or quiet retirement, the mechanism recalibrates. Another judge inherits the docket. Another vulnerability is assessed. Another alignment is attempted. The cycle does not depend on your personality. It depends on access. Power, you have learned, is not dominance. It is exposure to leverage. And once leverage enters the robe, it does not need to shout. It only needs you to continue signing.